Did you know that over 50% of the adult population in the UK does not have a valid will? People make all sorts of reasons for not getting a will drawn up, but statistics show that money and age are the biggest motivators. Only 6% of under 25s have a will, whereas 82% of those over 75 do. Only 9% of those with assets of less than £100,000 have a will, whereas 80% of people with assets of more than £500,000 do. Some of the biggest motivators or trigger events for making a will include having children, buying a house, becoming ill, or suffering a bereavement. A will is a legal document that sets out what you would like to happen to your money and your belongings after your death. These assets are known as your estate. The will should also outline how you would like your estate to be dealt with, and you can also include information on preferred funeral arrangements. You can make a will at any time so long as you are over 18 years of age and have the mental capacity to do so. If you neglect to make a will, you will not have control of what happens to your estate, your dependents, and other elements of your life. Between November 2007 and October 2009, the National Probate Service dealt with more than 254,000 estates, of which more than 42,000 were without a will. Where there is no will, the estate is referred to as intestate. There are many different scenarios that can arise as a result of not making a will. One of the most common problems that people without a will face is where they are not married or in a legal civil partnership. Even where a couple have been living together, there will be no right to inheritance. Did you know that there is no such thing as a common law marriage? This is a common misconception. If you and your partner are not married or in a civil partnership and do not have a will in place, then unfortunately normal intestacy rules will apply to your estate and your partner may not inherit what you wish them to. Only married or civil partners and some other close relatives can inherit under the rules of intestacy. These rules also apply where a will has been made that is not legally valid. If you are divorced or if your civil partnership has been legally ended, you can't inherit under the rules of intestacy. The amount that your partner can inherit under the rules of intestacy depends on the size of the estate. Where there is a joint bank account or building society, the partner will automatically inherit the deceased half. Where there is a jointly owned property, inheritance will depend on the type of agreement in place. And where there is a beneficial joint tenancy, the other partner will automatically inherit. Where there is a tenancy in common, the surviving partner will not automatically inherit anything. You should seek advice on the details of your arrangement if you are unsure. Children of the interstate person will automatically inherit where there is no surviving married or civil partner. There is no limit to this inheritance. If there is more than one child, the estate will be divided equally. Where there is a surviving partner, a child will only inherit where the estate is valued at more than £250,000. The following people may not inherit under the rules of intestacy: unmarried partners, partners not in a civil partnership, relations by marriage, close friends, or carers. It is possible to make a will by yourself, however it is advisable to use a solicitor so that you can be sure that it is legally valid. A solicitor will also be able to advise you on matters concerning inheritance tax. Before you meet with your solicitor, there are a number of things that you should consider. You should think about how much money you have, what property you own, who do you want to benefit from your will, who should look after any children under the age of 18, who should be the executor of the will, and do you want to donate to charity. You should be sure to review your will every 5 years and after any major changes in your life, such as having children, buying a house, receiving inheritance, or getting married. More information to support you in making a will can be found at www.direct.gov.uk, or you can visit your local Citizens Advice Bureau. If you have any questions about this video or you would like more information about Gordon Dean Solicitors' will writing service, please call our team on 01603 767671.